My name is Ravi. I'm from Armchair Criminal. I welcome you all to this part of the program. In this part of the program, we will consider common law exceptions to the hearsay rule. This is a large topic. Therefore, I have decided to break this large topic into 3 sections. In the first part, we will look at all the hearsay exceptions, save and except, for considering in detail the concept of res gestae and confessions, because they deserve to be treated as if they are topics of their own in their own right. You will understand why I have taken that decision when we consider them in detail. There are no exceptions to the hearsay rule from common law exceptions, save and except for what is being preserved in Section 118 of the Criminal Justice Act 2003. Equally, there is no scope to expand the topic either. Therefore, all the previous authorities been written off. However, there appears to be some gaps in common law exceptions to the hearsay rule. In particular, there's the possibility of a gap being created in public documents and public information. However, that can be cured by applying other parts of the legislation. In the first section of this program, which is this particular section, as I said, there would be 4 parts. But in this particular video that we are looking at, we will consider Section 118 of the 2003 Act, and I will identify what are the common law exceptions. There are 8. We will come to that in a minute. The general legal framework for the exceptions, and what is the implications of Section 118. So at this juncture, I ask the question, what does the legislation say? Section 118 preserves certain common law exceptions that can be admitted as an exception to the hearsay. Next, let's look at the legislation itself. Subsection 1 deals with the authority to have common law exceptions being admitted. The important parts of this section I have highlighted in red bracket. And basically it says this: subsection 1, the following rules of law are preserved. Then it lists 8 of them. That is the beginning. Then the end is in subsection 2. With the exception of the rules preserved by this section, the common law rules governing the admissibility of hearsay evidence in criminal proceedings are abolished. So you have subsection 1 allowing common law exceptions to be admitted. Subsection 2 says the rest, that save and except for what is being allowed here, everything else is excluded. Then the rest is in between. Now let's look at what are the 8 common law exceptions. The common law exceptions are: 1, public documents; 2, reputation as to character; 3, reputation of family tradition; 4, res gestae; 5, confessions; 6, admissions by agents; 7, common enterprise; and 8, expert evidence. So these are the 8 recognized common law exceptions to the hearsay rule. Each of these headings are treated as a rule. So the first one that we have is public documents. What is a public document? Any rule of law under which criminal proceedings, A, published works dealing with matters of public nature, B, public documents such as public registers and returns made under public authority with respect to matters of public interest. Next, subparagraph C, records such as records of certain courts, treaties, grounds, pardons, and commissions. D, evidence relating to a person's age or date of birth and or place of birth. We will look at the rationale for having them as they are. Second rule is reputation, second exception. What is reputation as to character? Reputation as to character is a person's reputation is admissible for the purposes of proving his good or bad character. There is a separate topic in the law of evidence which deals with, in particular, bad character. Bad character could be that of the defendant or a non-defendant, and that is governed under the 2003 Act. Next, reputation or family tradition. What is reputation or family tradition? Reputation or family tradition is admissible for the purposes of proving or disproving a pedigree, the existence of a marriage, the existence of any public or general rights, and the identity of a person or thing. Rule number 4 is res gestae. Here I only propose to look at the basic legal framework, then we will consider that as a separate topic in our next section. So what is res gestae? Res gestae is rule number 4. Any rule of law under which criminal proceedings, a statement is admissible as evidence of any matter stated if A, the statement was made by a person so emotionally empowered by an event that the possibility of concoction or distortion can be disregarded. There's a clue there. Always look for whether the maker of the statement was emotionally empowered to such an extent that the possibility of concoction, fabrication, can be ruled out. B, a statement accompanied by an act which can properly be evaluated as evidence if considered in conjunction with the statement. O, the statement relates to a physical sensation or a mental state such as intention or emotion. You would note, with regard to res gestae, it's all to do with balancing and cross-checking whether there could be room for fabrication, and that is done by looking at emotional state and evaluating the evidence as a whole to determine whether it is within the concept of res gestae. But we'll have a look at this later on, because this is a very troublesome area for most people. And as I said, this is a subject which is misunderstood by many, causing injustice to many. Therefore, it is only proper that we analyze and examine res gestae as a topic of its own. Consequently, I am not going to dwell too much here. Next topic is confessions. This is rule number 5. Again, like with res gestae, I'm just going to touch here. What are confessions? Rule number 5. Any rule of law relating to the admissibility of confessions or mixed statements in criminal proceedings. You would come to know when we look at confessions, there's actually a definition of confession. What is a confession? And why confessions are admissible. It is a topic that I will consider just as res gestae as a topic of its own, but even at a later date, I hope to consider confessions in much greater detail. Therefore, at this stage, I do not propose to go any further. Rule number 6, admissions by an agent. What is an admission by an agent? Rule number 6, any rule of law under which criminal proceedings, admission made by an agent of a defendant is admissible against the defendant as evidence of any matter stated. B. Statement made by a person to whom a defendant refers a person for information is admissible against the defendant as evidence of any matter stated. It's important to understand that the concept of admissions by agent to operate, the person who's making the statement on behalf of the defendant must be his agent. If not, it will not operate. Understandably. This is particularly important not only for the defendant, but all his agents. That includes solicitors, police station representatives, counsel, his entire legal team could be affected. Next, equally, if we were to refer someone else for information, then what that person gives by way of information on behalf of the defendant would be admissible too. Common enterprise is the next topic, and that is rule number 7. What is a common enterprise rule? Any rule of law under which in criminal proceedings a statement made by a party to a common enterprise is admissible against another party to the enterprise as evidence of any matter stated. There is a similarity between this concept of common enterprise and agent. In the example that we talked about of agent making admissions, that person must be the defendant's agent. Here, if the two people concerned, man A and man B, if they were in a common enterprise, that is to say a conspiracy or a joint enterprise, then any admissions, statements made by one person would bind the other person. We will look at the rationale for that when we look at the topic in more detail. Finally, expert evidence. This is rule number 8. What is expert evidence? Expert evidence is any rule of law under which in criminal proceedings an expert may draw on the body of expertise relevant to his field. So provided the person is an expert witness, the expert witness can draw from his body of expertise, the relevant to his field information, and express an opinion. Finally, let's consider what is the implication of Section 118. Section 118 at least establishes two broad principles. Section 118 subsection 1 preserves 8 common law exceptions to the hearsay rule, which we just looked at the legal framework. Then remember, public document, public information, character, res gestae, confessions, admissions by agent, common enterprise, and expert evidence. The 8 exceptions. Then subsection 2 abolishes all the other common law exceptions to the hearsay rule. So the previous rules that existed are now long gone. As I said at the beginning, this is the framework. There will be 3 other parts to this section of common law exceptions to the hearsay rule. Once those 3 parts are completed, we will begin to study res gestae and confessions in more detail. And each of those topics will have several parts because they are large topics and deserve very close examination to understand the concepts. I hope you have found this brief introduction to the common law exception to the hearsay rule is useful, and that you will join me in the next parts to come. Thank you very much. God bless.